Here at Scout Legal, we process thousands of visa applications. Many of our clients are entrepreneurs looking for a green card option. For many entrepreneurs, the EB-2 National Interest Waiver visa is an ideal option. In this video we explain why, while sharing the ins and outs of how an entrepreneur might qualify for the visa. We have new immigration videos every week. If you are new to the channel, please hit the subscribe button and bell. You can also sign up for one of our webinars, or get a free immigration guide, by clicking the link below. The EB-2 Green Card is an employment-based immigrant visa. Usually, an EB-2 visa petition requires the employer to complete the labor certification process, or PERM. This is a time-consuming and expensive process that involves recruiting qualified U.S. workers who might be available for the job. The National Interest Waiver, or NIW, allows those applying for an EB-2 visa to avoid the PERM process, and to sponsor themselves. This is also called self-petitioning. As a result, the EB-2 NIW can be a great immigrant visa option for entrepreneurs. In fact, many EB-2 visa holders who want a green card consider the EB-2 NIW visa. So how does one qualify for an EB-2 NIW? To be eligible for an EB-2 NIW visa, the applicant must hold an advanced degree or the equivalent, or have exceptional ability. The advanced degree can be a master's degree, or it can be a bachelor's degree with 5 years of progressive experience. Exceptional ability means a degree of expertise significantly above that ordinarily encountered in the sciences, arts, or business. Note that the applicant does not necessarily need a degree if they can satisfy the exceptional ability standard. The requirements to meet the NIW standard was explained in a 2016 case called Matter of Donazar. Donazar established 3 prongs that must be satisfied to meet the NIW standard. 1. The first requirement is that the foreign national's proposed endeavor must have both substantial merit and national importance. This means that the work the applicant plans to do in the United States must have a significant, beneficial impact on some region of the United States. It does not need to benefit or impact the United States as a whole. It would be permissible, for example, for the applicant to show that the proposed endeavor has significant potential to employ U.S. workers, even in her local region. Also, the impact can be economic, but it is not required. For example, a job that furthers knowledge could have substantial merit. Or, an entrepreneur creating innovative technology and hiring U.S. workers could also have substantial merit. 2. The second requirement is that the foreign national must be well positioned to advance the proposed endeavor. This means that the visa applicant must show that they will actually be able to accomplish the job they are proposing. This can be shown, for example, through a combination of education, a track record of success, a comprehensive plan for the future activities, demonstrated progress already made towards the endeavor, and demonstrated interest from potential clients, investors, or other parties. 3. The third and final requirement is that it must be likely that waiving the requirements of a job offer and labor certification would be beneficial to the United States. The government can ask a number of questions to determine whether the proposed job would sufficiently benefit the U.S. These include whether it would be practical to secure a job offer given the proposed endeavor, and whether the contribution of the proposed endeavor is sufficiently urgent to justify foregoing the labor certification process. The applicant should also demonstrate that the U.S. would benefit from their unique and exceptional qualifications, even if other qualified U.S. workers are available. One way the applicant can strengthen her odds of satisfying this requirement is by showing that the enterprise will benefit the U.S. economy by creating jobs for U.S. workers. There is one other aspect of the EB-2 NIW visa that may be particularly helpful to entrepreneurs. It is possible to apply for an NIW at the startup phase, before the business is fully established. The Donazar decision specifically notes that the entrepreneurial venture does not need to succeed. Specifically, the decision states, "We do not require petitioners to demonstrate that their endeavors are more likely than not to ultimately succeed. The business must instead be well positioned to advance the proposed endeavor." This language supports the fact that entrepreneurs can qualify for the visa, on the basis of a new business that is still in the startup stage. However, it also shows that it is extremely important that the applicant have a high-quality business plan to supplement their proof of accomplishments. All of these are needed to demonstrate that the applicants are well positioned to create and operate a successful business. Navigating the complexities of case law and current trends often requires the expertise of an experienced immigration lawyer. For more information about qualifying for an EB-2 National Interest Waiver, or about applying for a green card as an entrepreneur generally, you can contact us by calling 212-223-2964, or by sending us an email. You can also schedule your consultation by clicking on the link below, where you can choose a day and time that is most convenient for you. We look forward to hearing from you.